Well, welcome to this week's Lawfi DAO working group on the digital assets consultation. So today we'll be going through chapters 16 to 19. And we went through a little bit of 16 last week, but we didn't finish. So we'll be continuing chapter 16 and hopefully going on to 16, 17, 19. Let me just see exactly. I'm having trouble seeing you. Joni, can you see my screen?
Yes, I can see you and the screen. I know it's difficult when you're sharing.
Sorry?
I can see both.
Okay, perfect. Fantastic. All right, so can you see now presumption of trust? Okay, perfect. So going on to the next couple of questions now, this one's on presumption of trust. So the question is whether the rights of users should be limited to personal contractual claims against a custodian, so in the context of where there's a third-party custodian, or whether they can benefit from equitable property claims as beneficiaries to crypto token entitlements held on trust. So whether there should be a presumption at law that these kind of arrangements create a trust relationship. Now, the consultation paper notes that there is a scope for this presumption to that parties to a direct custody relationship intend for it to take effect as a trust, provided, of course, that the arrangement satisfies the requirements for a trust at law, so the requirements of objects and subject matter certainty. And then it also goes on to say that this presumption could be held to apply unless there were clear and express indications that the entitlements of users or clients to interest in crypto tokens were to constitute personal or unsecured claims only. And if there was a clear and express risk disclosure stating that in the event of the custodian's insolvency, such interest will be available for distributions to the custodian's creditors.
Wow.
So that's the question.
Yeah. Well, that's, I think, a lot of terms and conditions by token exchanges, they don't go that far as to state the rights in an insolvency, but most of them sort of take this position where they don't tell the customer how the tokens are being used, or like just even an express statement that they will not be used, and that they will be segregated in a separate account. So my impression is that most of them, they say we don't want to create any fiduciary obligations. They expressly contract out of that, nor do they tell them how they're being used. So yeah, I think the question will be whether those terms are sufficient for the look back. And you know, obviously if these sorts of presumptions come in or are more clearly stated, then maybe consumers can better understand, oh, I don't want to do my business on this exchange, I'd rather do it on another one because they're clearer. But
So
yeah, there's still a lot of historic risk.
Yeah, it would depend on the terms and conditions of the particular arrangement.
Yeah, that's right. Yeah,
that makes sense. So the question says that it provisionally concludes that a presumption of trust doesn't currently apply, which is what we mentioned, and also that it shouldn't be introduced as a new interpretive principle.
Yeah, I do agree with that, because that's what
Sorry, I think
people
you might be
think.
on mute. Oh, yeah, there we go. Sorry.
Yeah, I think that's what people think. So they don't typically read the terms and conditions, but there is a presumption that the token exchange is acting as a custodian and it's more like a trust relationship. That is the general perception in the market. And they are shocked when an exchange does go into insolvency and they find out all of the tokens, or a majority of them, have been used for effectively proprietary trading, where the profits of that are kept to sort of distribute to the existing shareholders of the exchange. Or what I think is more often happening is that those profits are being used to subsidize the cost of custody and insurance, both of which are very high, and they're not being reflected in the customer's fees yet. So the trading fees, or an extra amount for the token exchange to provide custodial services, most of them are absorbing and trying to defray the cost of absorbing that by using the customer's assets.
Yeah.
Question whether that's correct or not, or whether it should be limited to a percentage.
Yeah, okay, so we agree with this. Perfect. Moving on, and it seems like we might be able to get through all 3-4 chapters today. Now moving on to chapter 17, so going on with custody of crypto tokens, this chapter focuses on law reform proposals, and there are 3 proposals. So firstly, whether the validity of certain arrangements under trust-based crypto token custody arrangements should be subject to the statutory formalities in section 53, subsection 1C of the Law of Property Act, which I've copied below, and if so, how such formalities could be set aside. Secondly, whether the efficient and speedy resolution of crypto token custodian insolvencies, which we mentioned, would benefit from changes to the allocation of shortfall losses arising in connection with commingled unallocated accounts, which we covered last week as well, or pools of crypto tokens that are held on trust. And thirdly, whether the relationship of bailment could be extended to apply to arrangements in respect of crypto tokens. So I've copied out the section of the Property Act there. So it requires that a disposition of an equitable interest or trust subsisting at the time of disposition must be in writing, signed by the person disposing of the same or by his agent thereonto lawfully authorising in writing or by will. So the question is, can these formalities be set aside under crypto token arrangements?
Well, it goes again to your interpretation of in writing, because a blockchain ledger record is a record.
Yeah.
It's just, and by you signing it, that is a cryptographic signature, but not a normal wet stylistic signature. So perhaps it may be arguable that these requirements are already satisfied. But maybe it gets confusing when if a token exchange does maintain their own sort of proprietary database. So really they're you know, I might say I want to sell Bitcoin, but they offset it with your balance, Iris, before it actually gets communicated to the Bitcoin blockchain ledger. And so in that sense, it's not my keys, it's not your keys, it's the database that the exchange is controlling. And so maybe I haven't satisfied the in writing, but the instruction for me to do for the token exchange to do the trade, again, that's an electronic record, but is it in writing because I haven't applied a cryptographic signature or a stylistic signature? Maybe there could be a tick box sort of thing that you agree.
Yeah.
But I mean, the statutory formalities are supposed to be, like the purpose behind them is that the person knows they are creating a trust over their property.
Yeah.
And so if you do away with that formality requirement, the question is, what's the substitute that a person knows? So I think the formality, just clarifying the examples in which it could be practically interpreted to fall within, like I still agree with the underlying principle of the formality.
Yeah, I suppose another consideration is signed by the person disposing of the same.
That's right, but that's hard too, because unless you have a person, it goes to me signing a transaction through my MetaMask wallet. You don't know whether it's actually me or somebody who has intercepted control of my keys.
Yeah.
And so this goes to that further requirement again of what extra third-party verification do I need at the time of initiating a transaction to prove that it was me? And if we had proper digital identity and verifiable credentials where you produce, where your wallet is connected to a digital identity, you produce a digital proof at that time, because you only have access to your digital identity. That is the kind of frictionless process that I wish the legal frameworks would support, because otherwise we constantly don't have good evidence that signed in writing by the person disposing of same is the actual legal owner.
Right.
Legal and beneficial at that time anyway.
So it sounds like fulfilling this requirement would also require to have those, the digital identity.
And verifiable proof, and then the zero knowledge infrastructure that preserves your privacy of your identity while producing the proof. So all of that is still being put in the too hard basket by most policymakers. They seem to want to get crypto licensing and crypto markets frameworks in without holistically considering the interconnection with digital identity, verifiable credentials, and zero knowledge infrastructure.
Very interesting. Should we move on to disposition? So this involves internal transfers between account holder and custodian. So the scope of this section is determined by the nature of the transaction. For example, if it's a direction from an account holder to a custodian, and also external transfers to an account or address owned and controlled by the transferor or by another person. This falls outside the scope of this section because it amounts to a termination of the trust relationship between the account holder and custodian. And then the chapter also goes into, did you have something you wanted to add into that?
Just to say that reflects the proprietary database approach of, we know that that's how centralized token exchanges are managing the internal transfers. So, yeah, I think it just reflects, I agree with it.
Yeah, and there's further discussion into the changes to the allocation of shortfall losses. So if a shortfall occurs and a custodian enters insolvency proceedings, then the allocation of losses will be dependent on the legal nature of the custody facility and the rights granted to users under it.
Yeah, because that means that the users are granted priority, in a sense, to the creditors. So depends on the legal nature of the custody facility and the rights granted to users under it. Well, this, in concept, I agree, but it goes almost to prudential requirements too. So if people think that their tokens are being safe custodied, and the exchange has terms and conditions that say we're entitled to use 80 to 100% of your tokens to, reduce fees payable by you, I still think it needs to go further, that there should be prominent warning. And this, so the Law Commission work is not proposing to do regulatory reform, like they're trying to clarify whether this is property or not, and then the things that go around it. But so I'm just trying to understand this sentence in that context, because I think they're limiting the context to insolvency proceedings, but the regulatory protections are still relevant here. And from a regulatory and a prudential perspective, how much are we willing to have everyday users lose for the sake of having perhaps a perceived lower cost, lower fee option of storing their crypto assets safely? And maybe you leave it to the market, but I think that in leaving it to the market, that's a key thing that the users need to be made aware of.
Yeah.
Yeah.
and that goes on to the questions. So the first one goes to the clarification, so whether there should be a clarification of the scope of that application, whether that would be beneficial for custodians and would help facilitate the broader adoption of trust law in structuring custody facilities in relation to crypto tokens or other assets and holding structures. So should there be a clarification of this section?
Well, if there is, then what a lot of them are worried about is that they're providing a financial product or a financial service for which they should have already been licensed. So if there are already clear fiduciary obligations where they're managing tokens, like or things on behalf of others, the question is there an expectation of the financial benefit or returns from that contract? And that's why a lot of the terms at the moment say, well, they don't say what's going to be done with the tokens or how it's applied to reduce fees. It's just this invisible wall, because they think in saying nothing, that's a way that there's no fiduciary relationship. It's not a managed investment scheme and therefore not regulated as such. So in requiring more disclosure, you're backdooring them all into a traditional licensing regime. And so perhaps that escalates the importance for crypto or token-specific licensing, because as we know, in Australia, a key requirement is professional indemnity insurance, and most insurance are not able to offer affordable policies.
Yeah.
So even if just that requirement is exempted with some sort of different insurance scheme.
Yeah, I was just going to add, if they do offer terms as well, it's difficult to get insurance terms in this space.
Mm-hmm.
As I'm sure you know, and I know as well.
Yeah, yeah, big topic of discussion. So I think, yes, clarification would be beneficial up to a point, but it has to be holistic and move in step with whatever the licensing and markets regulation approach is going to be to token activities.
I think another question is clarification by whom?
Yeah, the way I read that is in a similar approach to what they did with the legal statement.
Mm-hmm.
So by effectively issued by a judge or a former judge, so Jeffrey Voss, with the support of an expert panel.
Yeah, that makes sense.
It's sort of the closest thing you could get to a judiciary deciding on the interpretation of law, but without having to bring a matter to court.
Yeah, and then that would be persuasive but not binding.
Yeah.
So that answers the second part of that question. So if you think that clarification would be beneficial, what is the best way of So you've answered a question already. And then if any of the models suggested in the consultation paper would be appropriate, please indicate. Otherwise, outline any further alternatives that would be more practically effective or workable. So it sounds like the one you mentioned is the most practically effective and workable.
I think so, but it sort of depends on its schedule pending for Sir Jeffrey Voss, and who he would like to rely on, or some alternative, because you can imagine a scenario where it's not just this issue, but then there's the whole list of 100 things which are requiring legal statements. So yes, subject to maybe only the most important issues escalating to that forum.
Yeah.
With maybe something else to complement, like the triaging of what issues are most important.
Yeah. Okay, perfect. Let's move on. So the next question is on bailment. So under the current law, bailment occurs, and you would know this already, I'm preaching to the choir, where one person, being the bailee, takes voluntary possession of a possessable, meaning tangible object of property belonging to another. the Bay Law, usually for a specific purpose. So there's voluntary possession of a possessible object of property. The Bay Law retains superior title to the object, and at the end of the bailment, the bailee must either return the goods to the Bay Law or deal with them as the Bay Law directs. So presently, it's not possible to create bailments for intangible assets, which of course includes crypto tokens, as the permissible subject matter of bailments is limited to things in possession or tangible things. Gives the example of DeFi lending applications such as Make a DAO, which you would also know a lot about, Joni, where the debtor or the bailor would confer an amount of digital assets under their ownership as collateral to be possessed by the lending network in order to acquire a loan.
Well, this one is interesting because in Europe, you know, for the OECD Blockchain Policy Forum, the Europeans, you know, those that are in the European Union, I think it was those based in Switzerland, a couple of member states, they were saying there's just been a change to recognise that a token can be a thing in possession. That under their European civil law, they've had the understanding that thing in possession related to a tangible thing, but there's just been some clarification that's come out that says, no, it can include intangibles. Yeah. So I myself want to look at the specifics of how that's applied, but in civil law, it's very different to common law because it's like the principle is stated, and the fact that the principle is out there means that you can do it. It doesn't get so much into the specifics that we get to as we slowly progress the common law and our understanding of it. So this thing in possession and that it's limited to tangible things is very much a feature and a bug of common law. And so if there's no way that we can interpret that a thing in possession includes something intangible, then bailment laws are an issue.
Yeah.
So the way that they've exemplified it through the Maker protocol and then Maker DAO as a network, I still go back to, and I wrote a whole submission on this, that you need to know the legal and tax entity characterization of the DAO. And so if it already has legal personality, then you've got the counterparties necessary for a bailment arrangement.
Yeah.
But what you don't have, you still don't have the tangible thing.
Of course, yeah.
And so the difficult thing about property rights when you're interacting with Maker protocol is first whether it's a thing in action, like whether you've got counterparties, or if it satisfies some sort of thing in possession that is bailment. My thinking is you may not need to rely on thing in possession if you can already establish with the full facts of the scheme that you've got counterparties. So it relies on, if you characterize Maker DAO, the network, as an unincorporated association of persons, which is a deemed partnership, or it's a deemed company because of the features of that unincorporated association, then that's your counterparty. And so you do have a cause in action against one or many of those members if something goes wrong with the protocol, or you weren't warned, or, you know, whatever your claim might be, or that they might be the trustee if we're having a presumption of trust relationship. So they would call the protocol non-custodial because there's no trustee or there's no counterparty. But if you can characterize the DAO, then the question is the protocol that can operate autonomously part of that legal entity characterization, or is it still separate and we still need some sort of recognition of a smart contract as having a legal identity? And that discussion is happening in the digital identity expert circles. but it's still not happening with respect to property and thing in action. So I think just simply writing that in our submission to evidence the need for legal clarity on the entity status of a DAO and whether the protocol still remains separate to the DAO, depending on how autonomously it is known to function. And the Maker protocol is one of the blue chip ones. It's known to hold up in bear markets. You know, it liquidates as it expects to. It hasn't been exploited. So this one would be a highly autonomous protocol, and maybe that means it's worthy of its own legal identity. But we don't have any legal concepts or principles to establish that.
Yeah. Perfect.
And that's exactly the circles that we're going around in trying to get to the tax treatment in the ruling that we're negotiating with the ATO at the moment on behalf of a client, a separate client.
It's very exciting.
We'll get there eventually.
Sure. Moving on to the questions, we've already covered these, but provisionally proposed that legislation should provide for general pro rata shortfall allocation rule in respect of commingled unallocated holdings of crypto tokens or entitlements in the circumstances of custodian insolvency. Do we agree?
But what's the general pro rata? Like, oh, so maybe, yeah, so if there's like $100 left, then the proportions in which you held your tokens, that gets shared. But there could be $0 left.
Yeah.
So pro rata doesn't help. I think, do they mean pro rata as between? So I don't understand what it means, because is it that pro rata allocation is made just to the customers and creditors are ignored? Like, and in the creditors bucket, I would include the employees.
Yeah.
That are owed salaries.
I visualized it was, let's say I purchase 100 units in a fund that has 1,000 units. So I have 10% of those units.
Yeah.
And it's commingled. So the holdings are commingled. The units are in it. The pro rata would be how many units I have, or I hold.
Yeah, but disregarding creditors and employees.
I haven't thought about that.
Yeah.
No, I don't think it's clearly stated in the consultation paper.
Well, let's ask a question to clarify that.
So employees and creditors.
Yep.
Should we move on to question 34?
Yeah, let's do it.
We also discussed this previously, concluding that extending bailment or the creation of an analogous concept is not necessary at this time. If not, please provide specific examples of market structures or platforms that would benefit from being arranged as bailments.
That could not be effectively structured using the trust and or contract frameworks currently available. But that's the thing, like, we can structure them as if trust concepts are meant to apply, but if a DAO is not recognised as having legal personality, it can't function as a trustee in an anticipated trust-like relationship. But then you could go further and you could say, you know, for all users intending to interact with this protocol, which is DAO governed, we intend that the smart contract is a trustee, but you can't, like, a contract can't just say that if a trustee is not validly formed or recognised under the relevant Trustee Act. So in that case, you would have to rely on bailment, and bailment would still require the recognition of the counterparty. So it still gets us back to the underlying problem of entity characterization, in my mind.
Yeah. I suppose contract frameworks would be a similar situation.
Yeah. Yeah, because it comes, even if it's specified in the contract that you say the DAO is the counterparty, but actually who do you sue? Or who is the person put into bankruptcy, or all of them?
Yeah.
Like, and this is the absolute clarity that we need, because until we get it, everybody is going to be hesitant to be involved in voting in DAO proposals.
Yeah, of course. Fundamentally, there needs to be a legal entity or someone to go after.
Yeah, limited liability, a framework for limited liability that still encourages participatory governance.
Yeah. Just getting that down.
Yeah. And there's not that same thing right now. Like, the closest that we have to it are people that might be shadow or de facto directors, but they're not actually appointed as such. But there's no incentives within a corporate for many people in the organization to act as if they're shadow directors. In fact, it's a bad thing to be a shadow director and not be appointed. Whereas in DAOs, it's the opposite. They want more people to be actively involved in community consensus and driving the organization forward. Like, so there's just no framework that I see that we can leverage from.
Yeah, interesting.
Okay.
Moving on to chapter 18. So we've got 2 chapters left.
Yeah.
And this one goes to collateral arrangements, which I think we covered in previous chapters as well. So at a high level, this involves granting recourse to certain specified property or pools of property to secure or otherwise cover a payment obligation or the performance of an undertaking. The chapter 18 goes through the applicability of common law concepts such as title transfer, as well as possessory or non-possessory security arrangements to crypto token collateral arrangements. Also talks about FCARS, the Financial Collateral Arrangements Regulation, and how that applies to crypto tokens, or whether it should apply, and also whether it would be desirable to develop bespoke statutory provisions designed specifically for collateral arrangements. I've briefly just defined at law just what a title transfer and security interests are. So just basically, a title transfer is the person who provides collateral transfers, which transfers their interest in the collateral in full to the collateral taker to secure cover a specified obligation. And then security interest is mentioned by Lord Justice Miller, the statement in that case, where there are only 4 kinds of consensual securities, which are pledges, contractual liens, equitable charges, and mortgages. And then also going through mortgages and charges. So mortgage is the transfer of ownership of an asset by way of security upon the express or implied condition that ownership will be transferred back to the collateral provider when the obligation secured has been settled. And a charge which doesn't involve the transfer of ownership but is a specifically enforceable right, which is created by either trust or contract to have recourse to a designated asset or class of assets to discharge a specific debt. Goes through potential issues with non-possessory security interests. So, for example, they may in certain circumstances require compliance with statutory formalities, which we've gone through. Where the grantor is a UK registered company, they're generally subject to public registration-based perfection requirements, and it might not be possible to enforce security rights under a charge, or it's not possible other than by exercise of a power of sale.
Yeah. But this is the Maker protocol example. It's more reflective of a charge, because from reading the white paper, you would assume that if it is non-custodial, because you can withdraw your collateral assets at any time, subject to you meeting the contractual obligation of, repaying the principal plus the stability fee. And the protocol only has rights to liquidate your collateral if your collateral goes below a certain leverage amount and you haven't topped up your collateral. So it certainly falls within that one of the consensual forms of security, but again, we just don't have to whom the right is specifically enforceable against.
Yeah. In the cases of DAOs.
Yeah.
Yeah. Yeah. Well, the question is that provision concludes that crypto tokens can be the subject of title transfer collateral arrangements without the need for specific law reform to provide for this. But this relates to crypto tokens more broadly, which is a very broad concept.
Yeah, I still think you get back to that problem if you haven't had a verifiable credential at the time that you agree to the title transfer. How do you prove that you were the legal and beneficial at the time that gave the permission?
I suppose, would it be sufficient if you were identified as the owner of the wallet or the person who has control?
So in that sense, the proprietary database records of the token exchange, or like whoever the collateral taker is, they would need to keep records of its Iris in connection with this account number and this wallet number. And they would need to ensure that that is always updated in real time, not like once a month. Because if there is any lag in that record keeping, that's exactly the problem, where you don't have the best evidence of your connection with a higher amount of assets, for example.
Yeah. So I suppose in answer to this question 35, we're saying there is a need for specific law reform.
Well, I just know that in the case of insolvency, like as soon as the token exchange announces that trades or withdrawals are paused, everybody submits their orders. And so you would just hope that within their systems, they do the snapshot of like what the position was before the announcement, or even like in the few weeks before they're going to make the announcement, because they may not be able to fulfill trades after that, like in the lead up, because they're experiencing issues.
Yeah.
So you could have submitted a trade, maybe it's pending for 24, 36, 48 hours, and those are the period that it may only be a couple of hours or a couple of days, but the volume of trades and what makes it confusing about your account balance and what you should be entitled to, that is what is going to go to litigation, and what the law is supposed to be clear about. And so if you had $100,000 staked in Anchor Protocol through Binance, for example, and you put in your order to redeem all of that a day before the death spiral started, but it wasn't fulfilled, that's the legal grey area of should that token exchange, whether it be Binance or anyone else, how what account balance do they honor?
Yeah.
And so then that goes to the prudential stuff of, even if you have this general pro rata presumption, should prudentially and for safe, sound and orderly, fair markets, an exchange is not allowed to put X percentage of deposit, like token deposits, in staking or in proprietary trading efforts. Like that is where it all falls down in in those few hours or few days of turmoil.
Right. Yeah. So that would be a statutory requirement.
It would have to be. I think that law reform would be needed. Well, maybe we'll have cases come through the courts with Anchor Protocol and with Terra and Luna. So maybe it can be clarified through the common law.
Yeah, that would make sense.
But a clear statutory proposal would help maybe even align with where the common law may go.
Yeah. I was just going to add, I know a case where as a result of, I think it was a technical error in the system of the digital currency exchange, I won't say which one. One of the previous firms that I worked for, our client at the time, he was able to purchase Ethereum for 2 cents per coin. And so he submitted the trade. He purchased 1,000 Ethereum or something like that. And then subsequently, a couple of days later, he found that his wallet showed that he had no holdings of Ethereum or Bitcoin. And so it seems like the exchange actually had changed his, had taken that out of his account and put it to 0.
And not notified him?
No, it didn't notify him. No, he went through the complaints process and there was no response, no adequate response. So that's why he came to us. But I thought that was a fascinating example.
Yeah, see that exactly, like it all triggers by how the proprietary database is managed. And we still don't have clear terms and conditions that tell us how they're managing it.
Yeah, and that company's terms and conditions were certainly not clear as well. Now, moving on to question 36, we provisionally conclude that non-possessory securities can be satisfactorily granted in respect of crypto tokens without the need for law reform. Do you agree?
I think just subject to the counterparty point, and legal entity characterization. Once that's clarified, then maybe a lot of the existing law is fine.
Yeah. If that makes sense.
Mm.
In the interest of time, I assume we'd like to get through chapter 19 as well.
Yeah, let's try.
Perfect. So I'll move on to the next one, still on chapter 18. So going through possessory security arrangements now, where the party taking security either has or will take possession of the assets that are provided as security, which includes pledges and liens, which are possessory security arrangements. Pledges are security interests created by the pledge's delivery of possession of an asset as security for the performance of an obligation. And a lien is a right to retain possession of a thing until a claim or debt has been satisfied. However, liens do not provide any right to realise or appropriate the value inherent in the detained assets in the event of a debtor default. The paper goes through multiple issues with these, including practical benefit. So there's a quote by Professor Sheehan. I'm not sure that in policy terms there's much advantage of being able to pledge a crypto token as opposed to charging it. What practical benefit does a lender get from being a pledgee that he does not from being a chargee?
I agree with that. But because a charge seems to make more sense in the case of protocol arrangements. Yeah.
I'm just moving on to the FCAR, so financial collateral arrangements regime. Broad range of crypto token market related activities could potentially be secured by financial collateral arrangements. And the paper notes that it's possible to argue that certain forms of crypto tokens already fall within the definitions of financial collateral used in the FCAR. However, FCARs implement a legal regime that was designed without any specific expectation that it would apply to crypto tokens and crypto asset markets, which of course is the case for most legislation. So moving on to the questions, we conclude that it's not desirable to make provision for data objects to be the subject of possessory securities, or to develop analogous security arrangements based on transfer or control.
Yeah, same answers as before.
Perhaps we can think of some market structures that would benefit from possessory security arrangements. I can't think of any off the top of my head.
I mean, maybe it will pan out when we get more asset tokens or asset reference tokens, and I prefer that term to use of the term stablecoin, because I think the word stablecoin is still used to refer to things where they maintain a stable value to like a commodity asset like gold. But stablecoins in my mind are more around fiat currency. So for asset reference tokens, you know, it's still unknown whether the existing laws, you know, and you know, whether I take gold and then issue a token that represents your ownership of the gold that I'm custodying. I suppose that the terms of the contract deal with, you know, the fact that you hold the token means that you can always have a claim to the gold, but it's the same issue with digital identity. If somebody steals my wallet and then they go to the gold custodian and say, I'll take all of those physical assets, thank you very much. It just all goes back to some sort of verifiable credential that means the thing that is the subject of possession can be connected with the token and the token's owner properly. And we haven't had enough real world assets be linked to tokens yet to see how that's going to be manipulated or abused. Or maybe we have and I'm just not aware of them yet, but I still think it's solved through digital identity and verifiable credentials.
Yeah, that makes sense. And question 38, we conclude that the financial collateral arrangements regulation shouldn't be extended to more formally and comprehensively encompass crypto token collateral arrangements.
Yeah, I'm not as familiar with the FCAR anyway, but you know, if it is already a charge, and that seems to describe most of the arrangements, maybe you don't need to deal with it there.
Yeah, I'll take a look more into that one as well when I'm up the responses.
I'm sure a lot of the UK lawyers will have something to say on that one who are familiar with the regulations.
Absolutely.
Yeah.
Okay, now this goes on to specific legal regimes. So should the UK develop a specific legal regime for crypto token collateral arrangements that directly recognises their financial and technical features? Mentions such a legal regime would need to strike a balance between the following. So the rights of solvent collateral takers to have the credit risk safeguards ever agreed and implemented, the rights of solvent collateral providers to obtain access to collateral that is not required to cover or settle obligations secured by relevant arrangements, supporting the efficient and stable operation of crypto token markets by recognising mechanisms that enhance liquidity. I'm just going through these quickly so we can get to the questions. Supporting broader participation and continued innovation in crypto markets, and controlling the fraud risk exposure of parties to collateral arrangements and third parties by establishing appropriate evidentiary and publicity requirements. So quite a few objectives there.
And they all seem great. And I just add, you know, incorporating a privacy preserving digital identity and verifiable credential approach, which, you know, you probably could read into any of those existing dot points, but it's worthy of its own dot point.
Absolutely. Having said that, moving on to question 39, we conclude that it would be beneficial to implement law reform to establish a legal framework that better facilitates the entering into operation, rapid priority enforcement, and or resolution of crypto token collateral arrangements.
Yes, but the foundation of that framework is identification of the entity.
Mm-hmm.
So yeah, I think that would be great.
Yeah.
And already, like with Maker Protocol, we've already seen it perform beautifully in a bear market, which would it's what would trigger a centralized token exchange to perhaps go into insolvency if it's put itself in very risky positions. So all of the operation, the rapid enforcement of liquidations, you know, all of that already automatically happens because the protocol automates it.
Yeah.
So the framework is more so for centralized, where you don't know what their protocol is, like their internal manual and automated protocols.
Yeah.
But the framework wouldn't benefit an open source protocol that everybody knows how it operates anyway.
Yeah, that makes sense.
Mm.
And do we have a view whether it would be more appropriate for such law reform to create a unified, comprehensive, and undifferentiated regime for financial collateral arrangements involving both traditional types of financial collateral and crypto tokens, or alternatively a bespoke regime for financial collateral arrangements in respect of crypto tokens? So should the law reform be unified, comprehensive, or bespoke?
Well, I think this is the $50 million question. Like, do you treat Web3 protocols as a separate world, like not part of the existing financial system? And if you do give a DAO legal personality or the protocol legal identity status, what happens in periods of downturn where there could be so much activity in that the desire to cash out or exit out of that separate system bleeds contagion into the traditional. So there's that nobody still has articulated a strong enough case for Web3 to be absorbed as part of existing principles of financial market infrastructure and safe and sound markets, or whether it should be separated with like entry and exit limitations and rules. And like I said, MakerDAO, you know, the Maker protocol performed as it would. So for all of the protocols that are out there, if you know total value locked, you know the prices of the relevant collateral tokens that need to be hit for potential significant market failure to occur, or at least that contains in Web3. So you can predict the contagion because it's all real time, it's all public, it's all available. What you can't predict is what's going on in those proprietary systems and how much risk is being taken. So I still don't have a good reference point for how they should be maintained separately or whether they should be unified. And if they are unified, then of course the argument is that stifles the free flow and the global access and deeper liquidity pools that are attractive to what has been Web3. Question whether it will still continue.
Yeah, so perhaps we don't have to come to a conclusion, but we can just state that in our answer.
Yeah, that needs input from IOSCO, you know, WEF, OECD, FATF, the Bank of International Settlements. Like that's a big question.
Yeah, absolutely.
Mm.
I'm not sure if we'll have time to cover chapter 19 questions, noting that there's, I think, 47 questions in total. So perhaps should we leave that for next week, or?
Yeah, I think so. Let's hold over.
Okay, perfect. Well, in that case, I might conclude this session, if that's okay with you.
Great.
Thank you for your time, Joni. Really appreciate it. And we'll see
you next week.
Have a good one. Oh, and good luck with the GM.
Thank you. Yes, I'll send you the invite now.
Thanks, Joni.
Bye.
I'll see you soon.